and it will be at a time when the weather is better and we're not frozen out. So anyway, welcome everybody. Thanks for coming. And with that, we'll get to our agenda, and as always, start with remarks from the Chief Justice.
Well, thanks, Chip. Just a couple of things. It was disappointing to have Omicron squelch our meeting in person, but now that the temperatures are in the teens here in Austin this morning, it would have been hard to do it anyway. We had oral arguments Tuesday and Wednesday in person in the courtroom, but yesterday we had to meet on Zoom because most of the judges couldn't get to the courtroom, and we were afraid. We had 3 lawyers from Dallas, and we were afraid they couldn't either, and the staff. So it just made more sense to meet on Zoom. But as much fun as this is, we're hoping to get to something else soon. Just a couple of things. The jury trials were picking up in December, but they're down a little bit toward the end of that month and in this month. And now I think courts pretty much are hoping to resume around the middle of February. And if predictions of a decrease, a real decrease in COVID are correct, then I think we'll be back in business on jury trials by the end of the month and hopefully in the spring. So meanwhile, we've extended our emergency order. We've got a little problem clearing some of our parental termination cases out. But we're working through the last handful of those and try to get back on schedule on those. We've also been trying to, you've read about Operation Lone Star in the press, no doubt. Our role in that is to make sure that the magistration and the representation of indigent defendants works like it's supposed to. So we've been trying to make sure that there are lawyers available to represent the people who are detained in Operation Lone Star. And we recently, just a few days ago, a couple of weeks ago, issued an order allowing out-of-state lawyers to come in and practice in Texas for the purpose of representing those folks. So we're just trying to make sure that the judicial side of it works as it's supposed to. We gave final approval to Trap 57, governing direct appeals to the Supreme Court. It's effective January the 1st. We gave final approval to amendments to Canon 6B of the Code of Judicial Conduct to allow constitutional county court judges to act as arbitrators and mediators. And last week, excuse me, we amended comment 10 to the disciplinary rules 7.01, effective immediately, to clarify that if a lawyer advertises a verdict amount that was never collected, the lawyer must disclose the amount actually received by the client with equal prominence. Then we've got the seizure rules that the committee talked about through a couple of sessions. And thanks to the committee for all the work that they've done on that. And they're already getting some attention in the press. So we'll get comments on those by the end of next month and try to make them final by May the 1st. And finally, we just approved some legal aid grants. Some of the money comes through our court. And we approved distribution of over $1.1 million to grants to the 4 legal aid organizations for legal aid for veterans. So those needs do not abate in the pandemic. If anything, they grow worse, and we're trying to meet them. So that's my report, Chip.
Great. Thank you, Your Honor. Justice Bland, comments?
No, good morning, Mr. Chairman. Good morning, everybody. Good to see you. No comments.
All right, great to see you too. Well, let's go to the agenda, which is full. I will tell everybody that I received a call yesterday from Senator Brian Hughes, who wanted the committee to know that some of the reforms for remote proceedings, which had passed the House but not the Senate, and that he and Senator Huffman were very hostile to the type of reforms that we're considering, and since that they had not passed the legislature, and wanted me to let the full committee know that they're interested and they would like to be involved in terms of giving them notice of anything we're thinking about doing. And I assured him that we were always keenly aware of the line between substance and procedure. We thought that we had a very good working relationship with the legislature over the past couple of decades, and would certainly take their views into account. He thanked me profusely, and he used the word respectfully a number of times, that he was respectfully giving this input, not meaning to intrude on what we're doing in any way, but just wanted us to be aware of that. So now our committee is aware of that, and obviously we'll take that into account as we go forward. But in the meantime, before we get to remote proceedings, suits affecting the parent-child relationship and out-of-time appeals and parental rights termination cases, and I think Bill Boyce, that one's back in your lap.
Yes, Chip, thank you. So I hope today to bring you a more focused discussion on a specific proposed rule, specifically pertaining to the piece of this larger project that involves addressing claims of ineffective assistance of counsel in a parental termination appeal when you're dealing with an accelerated appeal of the termination order to begin with. We had a fairly wide-ranging discussion last time. I'm not going to recap the discussion. I'm not going to recap from the discovery of fire for this project. I would refer you back to the October 5, 2021 memo, which kind of gives the background of the prior steps that we've taken so far. If you want to see kind of a roadmap of the overall project, you can look at section Roman numeral 2 on page 2 of the February 3rd memo that was distributed. And we are wrestling with section 1B now. And I hope that we can get to a point for a vote of a proposed rule for an ineffective assistance of counsel mechanism with whatever tweaks the full committee deems appropriate. And you'll see that there's some bracketed language that we're going to work through. If you want to see the specific rule that is being proposed, it's on page 3 of the memo under heading Roman numeral 4 in the middle of the page there. This is a proposed addition to Texas Rule of Appellate Procedure 28.4D. By way of real brief introduction, you'll recall that we've had discussions about different types of approaches to providing a means to raise a complaint of ineffective assistance of counsel by a parent whose rights have been terminated. I think the prior discussions coalesced around an approach that looks for a way to provide a mechanism for this within the ongoing appeal. And that's what this proposed rule 28.4D does. I'm going to tick through some of the revisions from the last version of this that you saw, and then I'll ask any of the subcommittee members to elaborate on any points I've glossed over or any points that they wanted to highlight. This is entitled Referral for an Evidentiary Hearing. And the concept here is that once the appeal of the termination order is underway, this provides a mechanism for a referral back by the Court of Appeals to the trial court for an evidentiary hearing. We had prior discussion about whether this should be a referral back for a recommendation. That tracks some of the current language in the Texas Rules of Appellate Procedure for these circumstances, for example, involving appeals from temporary injunctions. The subcommittee's sense was that this would be less confusing. This would be more familiar if it was framed in terms of making findings of fact and conclusions of law, both for purposes of everybody having a better idea of what standard of review might apply, and also to avoid any entanglements in terms of whether a court of appeals was somehow being asked to make impermissible fact findings in the first instance, as opposed to reviewing a trial court's fact findings. There's some discussion to be had around the type of showing that would be required in the Court of Appeals. We'll circle back to that after this introduction. You will see that there are a couple of placeholders that have been left empty in terms of a proposed time frame for doing this. Earlier proposals had a relatively tight time frame for doing this, and I think there was some concern voiced that it didn't really give courts of appeals enough time to adequately address this procedure. One of the open questions that would solicit the full committee's input on is whether we want to have some kind of a tolling built into this for the 180-day deadline under Rule of Judicial Administration 6.2a, and we can talk about that as well. So that's a brief recap, but I would ask if there's anybody else from the subcommittee that wants to add or highlight anything, to please do so before we launch into a larger discussion with the committee as a whole.
There's a way to raise your hand electronically if you want to do that, or you can just haul off and start talking. Bill, there are no hands being raised electronically or otherwise that I can see.
Well, let me just step in. I think, Bill, it would help to just tick off the 4 or 5 things we need to get resolved today. And, one is, what is the standard that the party has to allege in the motion? 2 is, when does that need to be filed in conjunction with the date of the reporter or trial court's record, trial clerk's record? 3, is it denied by operation of law? 4, how soon does the trial court have to make a decision? And then I think 5th is there some kind of tolling or abatement during that period? Did I leave anything out?
No, I think that covers all the bolded areas in the proposed rule.
Right. So I think that's what we really want to focus and get votes on today. Right.
Yeah, no, those would be the open areas of discussion.
Okay.
And that was Pam Barron speaking for the purposes of the record. All right, anybody else from the subcommittee want to weigh in on anything? All right, then comments from the full committee or questions.
Chip, this is David Peoples. On the first line or two, upon a showing of plausible, colorable, or a prima facie claim, what guidance is there anywhere about what the standard of care is for a lawyer, or what the elements would be for a prima facie case of ineffective assistance of counsel?
I'll take a stab at an initial answer to that, which is we would be applying the Strickland standard from the criminal context, which roughly paraphrased is no reasonable lawyer would do that or fail to do that, and prejudice as a result. So if we put it in terms of prima facie, I think we're saying a prima facie claim of Strickland in ineffective assistance as applied in this context. I think it was Chief Justice Christopher had raised comments at the last meeting that this was discussed in October, that the original reference was upon a showing of good cause. And that was, I think, appropriately identified as being very broad and undefined. So the options that were suggested were plausible or colorable or prima facie, all of which can be found in the case law in various contexts, in other contexts, talking about when something has been asserted with sufficient substance to it to warrant going forward. And so we would solicit the full committee's thoughts about what is the appropriate verbal formulation for that initial burden.
Does it matter, Bill, that Strickland is a criminal case and this is, even though the clear and convincing standard would apply on a parental termination, it's not criminal? Does that matter?
I think that based on the status of the case law, that the Strickland standard is already applicable for ineffective assistance in this context. So I think we're working within that construct.
Great.
But just to flesh that out, it could be as detailed as my lawyer didn't investigate, didn't call witnesses A, B, and C, didn't cross-examine on this area of, whatever it is. Maybe in final argument to the jury, admitted some things that he shouldn't have admitted, things like that.
Correct. A frequent source of Strickland complaints is the there was insufficient effort undertaken to find favorable witnesses, that sort of a thing. That might be the type of allegation.
This is Harvey. It seems to me that you would have to assert a second thing, which is prejudice. And I like the prima facie because it talks about both elements. I do think a note or comment would be helpful. I mean, the question David asked, I think, would be a question a lot of practitioners would ask immediately. I'm not sure what it means in that sentence to say upon a showing of a claim. I mean, when I hear the word showing, I think of evidence. And when I hear the word claim, I think of just an assertion. So I want it should be upon an assertion of a prima facie claim rather than upon a showing.
To your first point, Harvey, when you say there ought to be some accommodation for showing a prejudice, what sort of prejudice would be sufficient? I know in the habeas context, I've always thought that when there's an ineffective assistance claim and the courts require prejudice, that the guy's in prison, he's been there for 20 years, that is some prejudice. If there's a finding that the lawyer didn't do his job, but is it the habeas type of prejudice you're talking about, or something else, or how do you show that?
It's something else. It's to oversimplify, it's kind of a causation standard that yes, you have to show they did something wrong, but you have to show it would have made a difference, that it somehow prejudiced their case. So the lawyer making a mistake in final argument that wouldn't have changed the outcome otherwise as I recall, would not do it.
The specific language from the second prong of Strickland is deficient performance prejudiced the defense because counsel's errors were so serious as to deprive the defendant of a fair trial whose result is reliable. So I think that's kind of the elevated standard. And to address Justice Brown's observation, my understanding would be that the showing or the assertion of a claim for ineffective assistance of counsel would encompass both prongs.
Right.
And perhaps a note elaborating that we're applying the Strickland standard in this context would make that clearer.
Good. Okay, anybody else comments?
I have a question.
Roger?
Is there any sense in the subcommittee that the articulated grounds in the appellate motion confine the party at the trial? In other words, when you actually get your hearing, you're pretty much stuck with whatever you alleged in the motion and you can't show alternative grounds or alternative prejudices? That's my question.
I'll take an initial swing at an answer. Other subcommittee members may have other thoughts. Because this would be framed, let's say hypothetically, in terms of a prima facie showing, and then it gets referred for fact finding. My personal sense would be that once you overcome that initial hurdle and the Court of Appeals refers it to the trial court for further findings, then the record is going to be what the record is going to be. And I don't know that it's going to be, in my estimation, strictly confined to some sort of a detailed pleading standard. I think this first sentence of the proposed rule contemplates getting over that hurdle. And once you do it, then the record is going to develop like the record develops based on whatever evidence is there. That's my take on it, but others may have a different take.
Justice Christopher, then Pam, and then Richard Munzinger. Justice Christopher.
So I was a little confused by what Bill just said, actually, because so if we're likening it to the same standard that a motion for new trial based on IAC is, you are stuck with what's in your motion. So, I think that's an important part that needs to be clarified, right? In terms of the standard, it's very difficult for the appellate court versus a trial court to figure out whether they've made, a claim of prejudice, right? Because we haven't sat through the trial. We haven't read the transcript yet. And hopefully you don't want us to have to read the transcript before we rule on this motion, right? So what are typical claims? My lawyer failed to object to these two pieces of evidence, and it was harmful to me. Well, it could very well be that within that record, the evidence came in without objection. So, of course, there's no harm if in other parts he, didn't object, or my lawyer didn't call these witnesses. Well, are we going to have affidavits of the witnesses attached to this motion? And again, how am I going to figure out whether these witnesses were important to the trial versus the trial judge who sat through the trial? So, I think it needs to be a low standard at the appellate court before we send it back, because I can't answer, those questions without having a knowledge of the trial.
Great, thanks, Judge. Pam.
Well, I was just trying to get a little clarification on the prejudice standard, and I think Chief Justice Christopher just gave me that guidance that I was looking for, because it wasn't clear to me how that would be determined.
Thank you. Richard Munzinger. Hey, Richard, you got to unmute.
Because of my technical ineptitude, I don't have the language of the proposed rule in front of me. But does the proposed rule require specificity in the pleading in the motion so that one cannot plead a conclusion, but must plead the specific facts in the motion to allow the appellate court to make a judgment on those facts?
The current draft of the proposed rule does not have a specificity requirement for the appellate motion that would result in the referral. As it reads now, it says, upon a showing of a plausible or colorable or prima facie claim for ineffective assistance of counsel by written motion. That's as specific as it gets.
Well, the problem, it seems to me the problem with that is that I can file something with a general conclusion stated in the motion, and then I can prove anything that I want to prove at the hearing, which seems to me contrary to what the discussion has been this morning. I would recommend that the motion be required to set forth in factual detail the claims of the person who is seeking to set aside now all of this judicial effort, which presumptively has been done in good faith and in accordance with the law by the other side, at least. I do think it should be required that the person set forth with specificity the facts supporting the claim.
Thanks, Richard. Ken Sullivan.
I don't recall whether we've been down this road before, but I was curious the extent to which we've looked at what the history has been in other jurisdictions, what other rules are out there in other states.
If I may respond briefly, Chip, the short answer to Kent's question is we have not undertaken to survey whether there are similar rules in other states.
My 2 cents is always, it's, I think, helpful to look at who has the most experience. Some states are perhaps much further down the road and, have more experience under their belt, be useful to get that knowledge. But I understand how difficult it is with limited resources, but I'm a best practices guy. And so that's my 2 cents.
Thanks, Ken. Harvey.
The Chief Justice Christopher's comments, I think her comments are right on point if we're requiring a showing of a prima facie case. But if we only require an assertion, it seems like to me that makes it easier for the appellate court to just look at the face of the document itself and not try to look at whether there's any underlying evidence or any contrary evidence. You're just looking at the pleading itself and whether they asserted both elements of the Strickland standard. So I go back to my initial comment. I think the word showing should be replaced by assertion.
All right. Judge Mendoza.
Sorry, also, yes, I agree. I think that was a good point starting off, that it should just say upon the assertion of a claim. And then I am agreeing, though, that there ought to be some specificity requirement after that. I don't have the language. But I think that's not for the appellate court to review. Right? It's just the assertion of a claim, and we don't have to define it. And then it goes to the trial court for finding. But I'm joining the argument that we should ask for some specificity.
Great. Rich.
Is the sense of the committee that the specificity requirement could be covered by which word we picked there? Prima facie, plausible, colorable. I mean, if I have to show a prima facie claim for ineffective assistance, then that should tell me how much specificity I need to put into my pleading, enough to have a prima facie claim. I'm just wondering if the word we picked there might address some of the concerns about specificity, because it's going to set a standard of some sort for what that thing needs to say.
Great. Thanks, Rich. Bill Boyce.
So I'm going to offer these observations about the level of specificity that is required, because as you may recall from our prior discussions, because of the extra accelerated nature of these proceedings, this stands in contrast to the circumstance, for example, that Chip described, where you've got a complete state court proceeding followed by a separate, complete federal habeas process at which potential deficiencies can be ferreted out and developed at some great detail and length with a complete record. This is happening fast. And so I want to just put that consideration out there in terms of the level of specificity that's going to be required and how strict of a quote unquote preservation standard is going to be read into the ability to develop an ineffective assistance claim if it's referred, and how strictly that's going to be tied to language in a motion. That's one observation. The second observation is this. I think that part of the concept of this rule is that an appellate court is going to have discretion whether or not to refer this. And I think built into that discretion would be the level of specificity of the complaint. If the only complaint is, I received ineffective assistance of counsel and I want a referral, then I'm with zero further development or factual elaboration, then I think that's probably going to get perceived in one way by a court of appeals. Something that's a little more detailed in that there were witnesses X, Y, and Z that my lawyer could have called who would have given the other side of the story about why my rights should not be terminated, and those people were not contacted and were not called, then that's a different circumstance. So I guess the question to be considered is, how much specificity are we going to insist on? And in balance to that, how much are we going to allow that to be a factor that the Court of Appeals takes into consideration in deciding whether to refer?
Yeah. Richard Munzinger.
2 points. Number one, regarding allowing the words prima facie to be interpreted as requiring specificity in pleadings, I don't see any advantage to promulgating a rule that is ambiguous and requires interpretation to reach a requirement for the court to act, and I would be against it. If you're going to require specificity, you ought to say so. Secondly, my concern at the moment, and the reason that I say this, is a conservation of judicial resources. If I recall, Justice Gray at one of our last meetings where we discussed this spoke about the time burdens on the courts of appeal. You have to review the records. You've got to do this and that and so forth in order to reach a decision on this motion. Why would you want to allow these resources to be spent and to require to be spent unnecessarily? If you require specificity in pleadings, you at least know what have an idea of what the evidence is going to be, and you can form a preliminary judgment at least as to whether or not these things are or are not sufficiently grave that they amount to a deprivation of competent counsel. I don't see anything to be gained by ambiguity. I see nothing to be gained in terms of preservation of judicial resources in not requiring the person who now he's gone through a trial, he's had a trial, he or she has lost the trial, they have had a lawyer, there has been presumptively post-judgment motions, all of which have been denied, and he is now on appeal. He may or may not have participated sufficiently, I don't know, but why would you waste judicial resources and not require the person in this circumstance to prove that he's got a real reason for being there. I'm finished. Thank you.
Thanks, Richard. One question I had following Richard's comments, Bill, is when one of the options is plausible, is that meant to evoke the federal rule 12b-6 plausibility standard in pleading, or and possibly our 91A, although there's maybe debate about that, but in any event, 12b-6 in the federal system?
The direct answer is yes. As a more relaxed, I won't characterize it, because that could lead to debate about exactly how plausible gets applied. But yes, the direct answer is that we would be tapping into that, and plausible also appears in Texas case law as well, from time to time, in terms of talking about whether or not an assertion has been made, of sufficient substance to go forward. There's a number of analogs that potentially could be applied here. And if I may, I just want to put out one other very brief observation in response to Richard's observation as well, which is, I think his astute observation goes to the heart of the balancing that's at issue here, which is the rights that are being terminated by definition in this process are constitutionally protected rights. That's the genesis of this whole discussion about what are we going to do to provide a mechanism to make sure that constitutionally protected rights are not inappropriately terminated through a deficient process. And so practically every sentence in this rule is a balancing exercise between finality of the determination so that the children and the families can get on with their lives, versus recognizing procedural protections based on the constitutional nature of the rights that are being terminated. And so I think a discussion about how much specificity or strictness should be required is another example of the balancing.
But the plausibility standard at least is more rigorous than just notice pleading. So in that sense, it would be a higher showing or demonstration or whatever pleading, I guess, than otherwise, right? Than just notice.
Yes, and speaking for myself, not for the rest of the subcommittee, I have an easier time getting my mind around the concept of prima facie, because I think there's probably more analogs to that, maybe in terms of dismissals or burden shifting from employment context or things like that. I personally think that a prima facie standard has a little bit more of a settled meaning than other words such as plausible or colorable, but I'm confident there's other views on that, and I'm not strongly advocating that. I just make that observation.
Great, thanks. Connie.
I wanted to echo Bill's comments about, first of all, the constitutional rights here, but also that at this stage, in this posture, the standards should be lower, less specificity, I think a lighter burden. And remember, I mean, if you've been dealing with an ineffective counsel, you may be all of a sudden dealing with a brand new lawyer who's just coming to the file. A person could be pro se. And so I think you have to look at this through the lens of, this is a mechanism to get this issue out of the Court of Appeals back to the trial court, where the trial court is very well suited to look at this through the lens of having seen the entire trial. It's just as Chief Justice Christopher pointed out, they're very well equipped to look at the allegations and the evidence in the context of having lived through the trial. And it's a fairly quick procedure. And so at the point when they're first raising this, they may not have gotten evidence or discovery, and they certainly wouldn't necessarily have testimony from the lawyer who was ineffective. And so I think we should look at this through the lens of lightening the burden at this stage. And so for the standard, I'm in favor of either colorable or prima facie, because I think that just states the claim without having to have sufficient evidence or specificity to try to raise it to some plausibility standard.
Thanks, Connie. Justice Christopher.
So, again, so what kind of specificity are we going to require in the motion? Are we going to say, okay, I've looked through the record, he failed to object to these two things, and it prejudiced me. Well, the prejudice prong is the hard part for the Court of Appeals. It's the same thing with these two witnesses were available to testify and they didn't call them. And here's what these two witnesses would have said. All right. And that prejudiced me. Again, to determine in any way, shape, or form that there was prejudice, you have to look at the entire record. Right. So I think we have to be careful on our specificity. Now, I would suggest that you would have to say it was these two witnesses and attach an affidavit from the witnesses as to what they would have said, as opposed to they didn't call any witnesses on my behalf. That's not specific enough. I think that the prejudice part can be more conclusory at this stage. Because that ultimately is for the trial judge to determine.
Okay. Thanks, Judge. Richard Orsinger.
Thank you, Chip. I think that specificity and the standard of proof of the burden of persuasion are different. I like prima facie because that's well defined in Texas case law. But if there's no specificity requirement, just an assertion that my lawyer was incompetent could arguably be prima facie showing of incompetency. We considered the degree of specificity in connection with the recusal rule. And just for purposes of reference, Rule 18A, subdivision A4, requires that the motions must state with detail and particularity facts that are within the affiant's personal knowledge, except that facts may be stated on information and belief if the basis for that belief is specified sufficient. Well, I can't read the last word there, but the point is we grappled with this issue on the recusal motions and require detail and particularity of facts that are within the affiant's personal knowledge. To me, specificity has to be part of this rule, or else the standard of proof doesn't mean much. So I would be in favor of having a very general requirement of specificity, like detail and particularity of facts based on personal knowledge, coupled with the prima facie standard. And then if you've included enough facts that, if true, would create an issue, a debatable issue about disqualification, then you should be entitled to this process. Thank you.
Thanks very much, Scott.
I want to add something to the context about the constitutionality issue, which is of course very important. But that's the other thing that we in the subcommittee had to balance was the rule that says, the court is supposed to decide these cases within 180 days. So there's this balancing between the constitutional right and the need to get this done quickly and have the family and the child have some kind of finality. We don't have the luxury of what they have in the criminal system, where you can file a habeas corpus years and years later. So I'm leaning towards what everybody's saying about making sure the pleading standard is fairly low. I like Harvey's idea of saying assertion instead of showing. Thanks.
You bet. Any more comments? Yeah, Scott, you just spoke, so you can take your hand down. Anybody else? Seeing nobody. Bill, do we need to vote on plausible, colorable, or prima facie?
Yes, and I think what I would ask is, before we get there, we vote on on Justice Brown's suggestion regarding assertion instead of showing.
Okay,
So can we start with assertion?
yeah, certainly. Anybody want to be heard on the assertion showing debate? Yeah, Judge Mendoza.
So I think I already said that I was in favor of that, but after Mr. Orsinger, I think that's a great idea. They've already grappled with the specificity thing. I think it should be assertion of a claim without plausible, colorable, or prima facie, because then I think what follows is by written motion stating with, I think he said, specify details and particularity, and that's enough. And given this sort of tight time frame, to give, information that you want more than just say, this is an IAC claim, but without sending people to research what is plausible, what is colorable, what is prima facie.
Okay, Marcy.
So I agree with the idea of assertion with detail. But I just want to echo what Chief Justice Christopher said about prejudice being very difficult to articulate, especially for lawyers and judges, much less people who just feel like something went wrong in their case. To actually show how it prejudiced their case may be difficult. So I would not hold that, the prejudice prong, to a standard of specificity that arguably can't be met by by individuals.
Great, thanks, Marcy. Justice Gray, you had your hand up, but then it looks like it came down.
I'll speak if I may.
Certainly, anytime.
Well, no, I don't get to speak over you or Justice Heck, so not anytime.
Don't forget Justice Bland.
Well, we kind of came up. Never mind. I won't go there. To me, this is kind of like choosing a wine for a meal, and there are just a lot of moving parts to this, and to vote on this one at a time, which is historically the way we have done it, is somewhat complicated, because depending on what goes in that next blank of how much time you have to file this motion depends on what I vote for on whether or not it is a showing or a allegation. To me, the term showing would require the type support that has been referred to as the affidavits of the witnesses that are going to testify, but that were not called or were not discovered, or in other words, a showing requires a showing of a prima facie case, which require evidence to be included with the motion. The problem with that is if it is, as I think the original draft that came to us was, and I'm talking about on the referral from the legislative task force, it was, I think, 3 days in there or something like that, or 7 days, excuse me. There's no way that an appellate lawyer is going to be able to get the record and make a showing of ineffective assistance of counsel, being both prongs of deficient performance and prejudice, in 7 days. And so it's hard for me to address the one without the other, but am I correct, Bill, in understanding that the distinction between an allegation and a showing, whatever the next term is the difference between including the evidence of the ineffective assistance of counsel versus merely an allegation of? And I'll stop there.
Do you want me to go ahead and respond directly?
Yeah, go ahead, Bill. Yeah.
I mean, that's my understanding. We're dealing with some shades of gray here, no pun intended. But I think in a showing has more substance to it than an assertion. And so one thing that I might throw out for the larger consideration is, would a formulation upon an assertion, with reasonable particularity of a claim for ineffective assistance of counsel by written motion, would that be an appropriate balancing here? It introduces the notion of particularity, but it gives some flex in there. I think going to Chief Justice Christopher's point that it's an appellate court may be better able to or have more information available to it to think about whether or not there's an arguable failure to do something, as opposed to getting into the prejudice prong of it, which a court of appeals is going to have a much harder time assessing at the outset. So would assertion with reasonable particularity, would that formulation strike an appropriate balance?
Okay, Eduardo. You got to take off mute. Nope, you're not off yet.
If you can't find it, just hold your space bar down while you talk.
It looks like there's a mosquito on his screen that he's trying to get. There he is. Now we can hear you.
I didn't have a comment other than I was trying to figure out if he was talking about 50 Shades of Grey or not.
I deeply regret saying that.
Connie, up to you.
So I wanted to chime in and say I like assertion, and I also like the idea of taking out plausible, colorable, or prima facie claim. This isn't really a claim or a cause of action. This is not habeas corpus. This is a ground for reversal. And so maybe we solve some of these questions that we've all been grappling with by saying upon an assertion, I think reasonable particularity makes sense or something like that. But upon an assertion of with reasonable particularity of ineffective assistance of counsel. So we may take out some of these loaded words and make this a little bit more streamlined.
Okay, Judge Evans.
The recusal rule and reasonable particularity works well, but it also has an extreme to it where it goes past notice pleadings and becomes evidentiary. And of course, that's because the rule requires you to be able to show the grounds as though, and they have to be sworn to. So I'm not sure how far you want to go in this context, since you're sending it down to the trial court for an evidentiary determination. But I will say that the reasonable particularity gets us past the conclusionary problem in recusal hearings very, very well. And of course, otherwise, but it also allows us to rule on some in a summary fashion on those that are complaining only about rulings. So I think that's a good move there. I have to admit, I'm not too sure I know the difference between assertion and the debate there, but prima showing and how I would apply that as a trial judge, but maybe that's why I was a trial judge. So.
No court of appeals for you, Judge Evans.
Obviously not. I've passed that day.
Harvey.
I like Bill's suggestion of an assertion with reasonable particularity, and I'm also fine with dropping prima facie. I still think that a comment telling the practitioner that this is going to be looked at through the lens of the Strickland standard is just a comment, accomplishes both the direction that we want to give, but at the same time, the flexibility that Chief Justice Christopher was talking about.
Okay, great. Thanks, Harvey. So Bill, if we had a vote, somebody might be in favor of upon an assertion with reasonable particularity of a claim. Is that one side of the vote?
I'm building off of Connie's comment. I think it would be upon an assertion with reasonable particularity of ineffective assistance of counsel.
Okay. So strike all that other language in between. So that'd be one. And then the second would be sort of as you have it here, but with three options: plausible, colorable, or prima facie, right?
Yeah, I think that would turn it into a binary vote.
Okay. So let's have a binary vote. I love that phrase. Because we get all messed up if we have trinary votes or fourpinary votes or things like that.
I'm easily confused, so.
Totally. But let's do binary for this one. So everybody who's in favor of the language upon an assertion with reasonable particularity of ineffective assistance of counsel, raise your hand. Okay, and all for the other option, the other binary option, which is upon a showing of a plausible, colorable, or prima facie claim for ineffective assistance. Raise your hand.
Can you lower everybody's hand?
Yeah, lower the
voted.
last vote. And now raise them for this vote. If anybody's raised their hand, I don't see it. So I'll say we're unanimous. 36 people, the chair not voting, raised their hand for the language I first read about an assertion with reasonable particularity. So that will carry the day, Bill. Let's go on to something else.
So to Chief Justice Gray's point, I think that standard then is going to drive what we want to do about the numbers of days that stuff has to happen within after we get there. So I guess the first placeholder is how long do we want to allow for the motion to be filed after the clerk's record or the reporter's record is filed. So this would be the number of days within which you'd have to file the first piece of this in the Court of Appeals.
You got a suggestion?
I think if we're not requiring an evidentiary showing of some kind, but merely reasonable particularity, then I think a shorter time frame would be appropriate, and I'll open the bidding at 7 or 10 days.
7 to 10 days, okay? I'm trying to mute my clock here in the background. Harvey, did you want to say something?
Nope, I'm good.
Who else has a thought? Justice Christopher?
I'd be in favor of 7, just because, you have to file your brief within 20 days of this time frame. So, they need to get in there and get working on it. Especially we haven't really talked about here what we're going to do about briefing deadlines while the case is referred back to the trial court.
Hey, John Warren says 7 business days by message. Thank you, John. Justice Gray.
Again, because there's a lot of moving parts here, to make an informed decision on this part of it, I need to know what happens in the event that the appellate counsel does not get it filed within 7 days. Because if this is a situation where you have a right to this hearing on an ineffective assistance of counsel claim and you use it or lose it in your 7-day motion, then 7 days is not enough. If you can file an ineffective assistance issue in your brief 20 days later, then maybe it is, maybe it isn't, because what we're getting here, hopefully, is a record on whether or not, and I apologize, Chip, I've got one of those clocks in the background that's going to tell us it's 10 o'clock as well.
That's okay.
I feel like I almost have to wait for it, but I'll try not to. But you've got to wait to see, what happens with the issue in the event this is not raised in the 7 days. The other part that is a problem is we actually see relatively few of these ineffective assistance of counsel claims raised by the appellate lawyer that has been appointed to review the appointed trial lawyer's conduct. There's 2 places that then happen that would seem to be kind of caught within this rule. The first is what happens when the appellate lawyer files an Anders brief and it is raised for the first time in the response by the appellant, by the actual parent, former parent at that point, I'll say biological parent, that files a response of not only was my trial counsel ineffective, my appellate counsel was ineffective for missing the deadline for raising the ineffective assistance issue, or was ineffective on other grounds. And then you find this situation in private termination cases where you wound up with a termination. And I tried to go back to the full rule of 28.4 to see if this would capture private terminations, and it seemed like it would. My recollection is that private terminations are still governed by Rule 28.4. And so the situation there is that, they just don't get it done in 7 days. It just doesn't happen. But that would be what I would need to know, particularly, is it a use it or lose it, before I would bind someone to a 7-day period. Thank you.
You bet. Lisa.
I think Chief Justice Gray raises some great points there. One thing I would encourage is, at minimum, it should be a 10-day rule and not a 7-day rule. This is not something we can calendar, right? We're at the mercy of when the record comes in, and as somebody who, I don't do them, but my partner Carlene does these, that they can come at inopportune times, right? And I just think 10 days gets you a weekend on either side, or I was in Italy, but I came back and did it immediately, or whatever. But 7 days is really a very short time frame, given that this is not something we calendar, right? This is something, a record gets filed and then we can calendar it. It's not calendared from a date certain that we know in advance. So that would just be my plea, that it be 10 instead of 7 at minimum.
Okay, what about 7 business days like John Warren suggested?
I don't like business days in general because that's not the way my brain works. So, but that would be more helpful. That, I mean, I think 10 gets you mostly 7 business days. And it's something we're more familiar with in the context of rule counting under the rules of civil procedure and the rules of appellate procedure.
Okay. John, note this for the future. Lisa's brain does not work on business day calendars. So we got that going for us.
Chip, if I may, the reason I said 7 business days was to give that additional cushion. But given that now we have the ability to do things more electronically, wouldn't that actually be able to allow a party to get the information, or receive notice, get a response, and get the information filed within, I guess that's in a reasonable amount of time? I mean, at some point, when we start addressing calendaring, we also have to factor in the new normal, which is not necessarily sending things by paper, but doing more things electronically, and that includes signing and notifying, and even collaborating with other parties.
Yeah, good point. I think Lisa is positive. Really good point, because Lisa's positing the situation where, maybe it comes in late Thursday. She's taken a 3 or 4 day holiday to Turkey starting on Friday. So with 7 days, she's already, 3 or 4 days into her time limit before she even checks emails. So, right, Lisa, that's how your brain's working on this.
Yeah, I get under the, for instance, I do some work under the Public Information Act, and that statute does do business days. It throws me off every time, because it's not that I can't count business days, and I know it happens in context, but it's just not how the rules typically work in the court system. So.
Right. Got it. Thank you. Justice Gray.
I'm sorry, Chip, this is Chris Porter. I was just going to
ask. Yeah, Chris, go ahead.
Just one quick question. Would it be, could this be something maybe where we can build into the language, just something like, and a request for an extension, a reasonable request will be, not freely given, but we could, you could seek a reasonable request, and whatever the language is to suggest that, as long as it's something that it works for both sides, or it works for the court, then that's something that will be granted. I know, for instance, extensions at the appellate courts are typically, 30-day extensions are typically agreed upon at least once or twice. And I'm just wondering if we could build something in here, some similar language.
Yeah, so a cushion in case somebody misses the deadline or is about to miss it. Yeah.
Chip, I was just going to say, based on what Christopher was just saying, attorneys file their vacation letter. So I think at some point that would be kind of a placeholder for any action that may occur within that time frame.
They do in Dallas and Harris counties, but not every county do you file a vacation letter. Just having gone through that recently. Somebody else had their hand up, but maybe they took it down again. So Judge Miskell says, we don't file vacation letters in Collin County. That's right. And not in Travis County either, I might add. So,
I'll withdraw that comment. It was never said.
Yeah, pie in the face on that, John. Bill Boyce.
I'll make a couple of observations in response to Chief Justice Gray's comments and to Lisa Hobbs's comment, which is as I understand this concept, this proposed rule would not foreclose raising an ineffective assistance of counsel claim, even if an initial motion deadline is missed, although an ineffective assistance of counsel claim without any backup evidence is not likely to go very far. So I make that observation. However, that plays into the time frame. Number two, I'm sympathetic with the concerns that Lisa has voiced. the constraint we have is a 6-month time limit for deciding these cases. And then I also flagged for your consideration that Texas Family Code 161.211 puts an outside time limit on when a collateral attack could be raised, also 6 months. So normal freely granted extensions that might apply in other circumstances are not going to fit well within this, because the Court of Appeals doesn't have the usual flexibility that would apply in other circumstances. And so to sum up the comments, I think 10 days would be reasonable. The difference between 7 and 10 in light of the overall 6-month limit is not humongous, but I can see where it would be impactful for individual attorneys.
Great, thanks. Richard Orsinger.
Just wanted to say that our whole discussion has to do with those ineffective assistance of counsel issues that require a development of a record other than the record of the trial. So you can still raise your ineffective assistance of counsel in a brief for grounds for reversal based on the record that the court reporter has forwarded. So these are situations where it's something that's not in the record, which typically is going to be a failure to call witnesses or a failure to interview witnesses, rather than something like the failure to make objections or the failure to object to a defective jury charge.
Great. Roger.
Thank you. I favor the 10 days largely because I think the new normal has to be considered in light of the fact that a lot of these cases may be handled by small law firms or solo practitioners. And part of the new normal is trying to find, keep staff is not easy. I'm not going to go into my own personal problems, but I think we have all had the problem that we've seen staff decimated both by illness and by just, if I can't work from home, I don't want to work from you anymore, et cetera, et cetera. So I favor building in some leeway. I mean, the 10-day. The second thing of it is somebody talked about extensions. And given that we are on a, so to speak, kind of a rocket docket, we have outside constraints on time to decide the case. If we're going to allow an extension, we build in something like we do for TROs, that you only get one extension for a particular time period, and that's it. And no more extensions by agreement or whatever. I mean, I don't like to be draconian about this, but the clock is ticking on deciding the case, and we don't want people to use this as a way of running out the clock or something. So again, if we're not going to allow extensions, that might be worth putting in. But if we are, then I say, I would recommend that we specify the length of the extension that can be granted, and only one, whether by agreement, even if it's an agreed motion, you only get one. And that's my comments.
Thanks, Roger. Justice Christopher.
Yes. So in the IAC world, you almost always need a hearing, even if it's something that is apparent from the record. So you failed to ask for something in the jury charge. Okay. That could have been the strategy of the lawyer, as opposed to oh, I didn't think about it. Why didn't you object to this? Well, I didn't object to this because I wanted to get in this other piece of evidence. And I knew if I didn't object to this, I could get in this other piece of evidence. So in the criminal concept of IAC, if there is not an evidentiary hearing, we often say at the appellate court, there's no evidentiary hearing here. we can think of a reason why a plausible reason why the trial judge didn't do these things. And therefore we deny your IAC, because on the criminal side, you can then file your habeas. So, I mean, we're kind of in this weird hybrid situation here. And I mean, that's something to consider too. Because, you know, normally you give the lawyer a chance to explain why he didn't do something. And without that, and, you know, so I disagree with you, Richard, on it's going to be apparent from the record and it should only be something like witnesses. I think, you know, unless we have a whole new standard for IAC in these cases, we're going to want to, we at the appellate court are going to want to see why the trial counsel did what they did.
Perfect. Thank you. Lisa Hobbs.
I agree with that. And also just if you don't accept what the chief just said, then you're getting into where you're conflating harmless error with the higher Strickland prejudice standard. Because we can do harmless error on records, but you know, it seems like Strickland is looking for, I don't know, it's at least different words. I assume it's a different standard too. The thing about the extensions of time, as somebody, again, I don't, my name's on these briefs, but these are really Carlene's appeals that we handle probably monthly. We know we can't get extensions, like, unless we have a really good reason. Like, the courts are very good about denying even agreed motions for extension in these cases. Or if you had COVID or something really, you know, then they may give you a short extension. But I just think the courts of appeals, just in the general termination cases, they've got it down on what their comfort level is for when this needs to be rolling and when you've given them a really good reason to give you a few extra days. But you don't get, it's not like general appeals where you get 30 days if it's agreed to. It's just, it doesn't work that way. And the lawyers who handle these cases generally know that they're on a very short leash if they're asking for more time for any part of this case.
Yep. Justice Gray.
Well, to echo what Lisa just said, we can deal with the motion for extension. It doesn't have to be in here. The parties know they can file one. They know that the amount of the extension is going to be limited if it's granted at all. Also, remember the 180-day deadline is a performance measure evaluation of the Court of Appeals. It doesn't affect the litigants other than the actual delay. And so, you know, we factor that in, that it does affect us, but there's no result that is affected by crossing the 180-day threshold. It just, it is a somewhat arbitrary selection of a time period by rule of judicial administration. My question, though, however, is more fundamental in that, why do we need to put this deadline for filing this kind of motion in this rule at all? Why do we need the deadline other than it's got to be filed by the time that the brief is filed? And I realize that you may wind up briefing an ineffective assistance of counsel issue and also trying to develop the record at the same time. But I don't see that as much of a problem as trying to get all the ducks in a row to file the issue as part of the brief, because you may be working on the brief on the night before it's due and you see a really good ineffective assistance of counsel issue, but you need an evidentiary record for the very reason that Justice Christopher explained, is that we basically presume, if one can be imagined, a strategic reason for doing whatever was done or not doing whatever was done, if a plausible reason can be imagined. And so, do we really need to peg it to the time that the record was filed, or would it be better to have the drop dead date of, you know, before the appellant's brief is filed. Thank you.
You bet. So until Justice Gray spoke there, I was thinking that maybe we had a consensus on 10 days, but now there's another element here. Anybody want to be heard on that?
Chip, can I make this
Yeah,
observation? While I recognize that the rule of judicial administration is a performance measure, I think it's one that the appellate courts take seriously and try to comply with. But at the end of the day, it is a performance measure. I think there's also the timing consideration by section 161.211 subsection A, which in paraphrase says the validity of an order terminating the parental rights of a person who has been personally served, etc., is not subject to collateral or direct attack after the 6th month after the date the order was signed. And so the concern that I have is if the deadline for filing the motion is pushed back or is not specified, then the courts of appeals are still bumping up against limits. They're going to get jammed up trying to deal with these motions. And as Chief Justice Christopher has observed, on an undeveloped record, these challenges are not going to go very far in all likelihood if criminal practices are applied in this context. So I would advocate for a 10-day limit or a 10-day deadline for filing the motion after the record is filed in the Court of Appeals, again, as another example of the balancing of interests that is inherent in every sentence of this rule.
Okay, Richard Orsinger.
Chip, can I ask Bill Boyce to clarify? Bill, are you saying that there is a rule or a standard that would preclude the Court of Appeals from sustaining a complaint like this at the 6-month period? Or is it just like a goal, but not a rigid deadline?
I think that the rule of judicial administration is more in the nature of a goal, but I'm looking at 161.211 of the Family Code that I think is also setting an outside deadline here. And so that's my concern. And if I'm not understanding the proper application of 161.211, then I ask to be educated. But that's what's causing some heartburn here.
Well, that certainly at the task force level, we believe that you could add on days to the end of the 6-month period for whatever delays you have built in for this. But your reference to that Family Code rule may indicate that you cannot add on to the 6. So even into this proposed rule in brackets, is you toll the running of the statute or the time no more than 20 days pending referral. We may not have the ability to toll it all. And if we don't, that affects these decisions we're discussing.
Fair enough. Well, unless there are other comments, and there may be, Lisa, do you want to have something you want to talk about?
Well, Justice Boyce, is that for asserting a collateral attack, or, I mean, not to go back too far in our votes, but, or is it from ruling? Like, do you just have to apply to collaterally attack it? Or do you think it's like a prohibition on a judge allowing a collateral attack?
I think it's like a bill of review. I think you can file it on the 180th day at 11:59 p.m.
That's the way I hope it is. But I was just curious at what I don't have the statute in front of me. Sorry.
The operative language that I'm looking at is, quote, is not subject to collateral or direct attack after the 6 month after the date the order was signed.
Okay, I know the answer because one was appealed to the Supreme Court out of my court, and it was filed on
All right.
at the very
Okay.
last minute of the deadline.
Okay, so there we go. So what about having a binary vote? And Bill, see if this works. One vote would be everybody who's in favor of inserting 10 days in the blank here on your draft rule. And everybody who wouldn't vote for that would be for something else, be it 7 days, 7 business days, or as Justice Gray says, tied to some other guidepost during the process. So how about that? Is that okay, Bill? We vote that way? Bill?
Yes.
Okay. All right. So everybody who's in favor of 10 days, raise your hand. Okay, everybody, put your hands down now. And everybody who is against the 10 days for whatever reason, raise your hand. Okay, everybody voted? So 10-day wins, 26-3, the chair not voting. And so we will now take our morning break and be back at 10:45.